right, typical disclaimers for any legal class. Well, we're going to put on law. We're going to talk about law today. Policy, just be mindful of that. It can be more restrictive. And on the Miranda issues, sometimes agency policies do require more than officers, more than the law does for officers. So make sure you're following policy. Any doubts about anything you see, push it up the chain and let someone of high rank and authority make that decision in your agency. And as always, we don't offer legal advice in our classes. We do, this is legal training, legal awareness, not legal advice. All right, and we're as we normally do in these webinars, we're going to talk about the federal standard. Just know that your state could be more restrictive on some of these issues. With Miranda, other than maybe a few states that have some maybe statutory um, requirements for Miranda and Miranda warnings, they're pretty much tracking the federal standard. So we're talking federal law today, but this is the primary law source of law for pretty much every single state when it comes to interrogations. All right, so first of all, the first point I want to mention about the law of interrogations is the corpus delicti rule, which it's an old common law rule, which basically it deals with the how much evidence and what type of evidence do we have to have in order to be able to support a conviction. And specifically when it comes to confessions, there's the rule that a person cannot be convicted of a crime just solely on their confession. Okay, so if we arrest someone and we do a custodial interrogation and they confess to the crime, and that's literally the only piece of evidence we have, that is not enough to get a conviction to prove the case beyond a reasonable doubt. You got to have at least what's called slight corroboration, some kind of physical evidence or a corroborating testimony from a witness to support that confession. Now, confessions, that's not to say that they're not valuable pieces of evidence in a criminal case. They often are, but it cannot be the sole basis for that. And the reason, a good reason, it comes from a case called Perry's case. That's where it originates from. This is a case where this guy Perry he confesses to a homicide, to a murder, and he's executed. But that's the only evidence was his confession. Well, turns out after he gets executed, the alleged victim turns up alive. There was no homicide, but obviously it's too late for Mr. Perry in any remedy. So from that case, we get the rule that you can't have just a confession. You got to have some slight corroboration. All right, now, regardless of whether we're talking about custodial interrogation and application of the Miranda rule, we still have to satisfy the voluntariness test when it comes to confessions or other self-incriminating information. So it doesn't matter if the person's in custody or not. This could be a consensual encounter. And the person we're interacting with maybe confesses to a crime or otherwise incriminates him or herself. It's still got to be voluntary. No matter obviously have to comply with the Miranda requirements, but regardless of whether we complied with those, um, and assuming they're applicable, it still has to be voluntary. I mean, I can have somebody in custody, read them a Miranda warning, proper Miranda warning, get a valid waiver, and the confession or whatever evidence I get from that interrogation still could be inadmissible if it wasn't voluntarily given. Which means of the person's own free will. That's really what it boils down to is has the government done anything to coerce the person into giving this self-incriminating evidence, as long as there's no threats, promises, undue coercion, then it should meet the voluntariness standard. By the way, I mentioned we're going to answer questions at the end of the program with the Search and Seizure Show, but if you have questions, you can type them into the chat. I'll keep glancing up and down from time to time to see if I see anything in there, and I'll do my best to try and keep up with those and answer the questions if I'm able to. So for any confession to be missed, it's got to be voluntary. It doesn't matter whether it's in custody or not. So even in custody, complying with Miranda doesn't do the trick to make it voluntariness. The reason why courts historically say confessions that are not voluntary are not admissible is because one, coerced confessions that are product of duress, coercion, threats, things like that, they're not reliable. Like, how do we know this person is confessing because they actually did it, or because they just want us to stop, harassing them or threatening them, or they just want the coercive environment to stop. Okay, so they're not inherently reliable. And the other reason is it's just fundamentally unfair to use evidence that's obtained from someone in an involuntary capacity. When it comes to self-incriminating evidence. So it's unfair and it just the evidence isn't reliable. That's why we have this rule. Um, just a few factors. I'm not going to dwell on this, but what are some common factors courts look at as far as things that we do during an interrogation that could affect voluntariness, how long the interrogation occurred? Obviously, the longer we keep this person the longer we question this person, the less voluntary the statement becomes. But by itself, there's no maximum duration we can possibly interrogate somebody. All these factors are typically coupled together. Whether this long, lengthy interrogation, whether it was uninterrupted and unrelenting, like we didn't give this guy a break, we just were hounding him for hours on end. If we move the suspect from one place to another, and then change the setting of the questioning, and we bring in maybe another officer to continue with the questioning, that's another factor to consider. It's not that we can't have multiple officers involved; it's just another factor. And then another one is whether we've held this person incommunicado, like not allowed him to make phone calls, talk to his friends, talk to his family, talk to his lawyer, those kinds of things. There's other factors as well. I'm just mentioning some of the common ones. And as far as the characteristics of the person who's being questioned, there are things that we look to there as well as to the voluntariness. The age of the person, obviously. The younger the person, the less likely we could show that it was a voluntary statement. Education level, mental capacity, whether undergoing some kind of like psychosis or psychological event. Has this person had prior interactions with the police? Is another factor. And then whether, of course, this person's tired or emotionally distressed, those things can be factors as well. So lots more we could talk about with voluntariness, but I want to focus most of this webinar on the Miranda rule and the associated rules that go with Miranda. It's not just the Miranda case itself, but there's all these other ancillary rules as well. So let's talk about the Miranda the overarching rule of when we're supposed to give Miranda, and then we'll talk a little bit about the warnings themselves. I want to spend a minute talking about the case. I think the Miranda case itself is a little bit interesting. So as a profession, and there's no question in my mind. Well, actually, before I get to that, where does it come from? Where does the Miranda rule come from? It comes from the Fifth Amendment, and this privilege against compelled self-incrimination. Obviously, a defendant in a criminal case cannot be forced to testify against himself or herself. They can sit there silently. They don't have to take the stand. You can waive that right if you want to. But this privilege against self-incrimination, it also extends to out-of-court statements as well, like statements made to the police when they're in custody. And the most recent Supreme Court case that deals with Miranda in any capacity is a case called Vega versus Tico. This is out of Los Angeles a few years ago, where for all these years there was a question in the lower courts with can if an officer fails to give a Miranda warning and he's required to, so he violates the rule, doesn't give a warning before he interrogates somebody in custody, is that something an officer can be civilly liable for? Can we sue someone, an officer, under Section 1983 for a federal civil rights violation for failing to follow the Miranda rule, or maybe continue the interrogation after they waive their rights? And the Supreme Court says no. No. Okay. So one less thing an officer needs to be worried about when it comes to civil liability. Violating the Miranda rule is not itself a violation of the Fifth Amendment. The violation, if there ever is one, it actually occurs in court when the prosecutor attempts to admit evidence obtained in violation of Miranda. That's when the actual violation of the rights occur, but not when the officer just fails to give the warning. So you cannot be sued successfully for simply failing to give a Miranda warning. So one less thing for us to worry about. Now, as a profession, there's no question about it. Anybody that has ever been to any of my classes when we talk about this, you've heard me say this. We over Mirandize people. as a profession, we read way more Miranda warnings than we have to. I call it handing out Miranda gift bags to our suspects. Which what I mean by that, it's a free complimentary Miranda warning we're giving to our suspect. I guess we're just so appreciative that they've agreed to sit down and have a conversation with us. We hand them this little gift bag, and inside is a free warning, telling them they don't have to talk to us, and then all of the other associated aspects of that. Well, it's not you're not really creating a legal issue. I mean, I can't say there's a legal problem with that, but I do have two concerns. I'm not a proponent of officers giving free Miranda warnings. One is you're potentially inhibiting your investigation. If I'm unnecessarily telling we'll call him your suspect, that he doesn't have to answer my questions, that's counter purposeful to the whole point of having this conversation. And he might after I give him this free warning, he might invoke his rights and say, well, thank you for reminding me that right to remain silent. I'm going to take you up on that and not answer your questions. Some of those people, my contention is that some of those people who are invoking their Miranda rights after having been given a free Miranda warning that one they haven't earned yet, some of those people would have talked to you. They would have answered your questions and potentially furthered your investigation, but now we've shut that avenue down. I don't know what percentage of people that is, but I think it's probably a substantial percentage. So we're potentially inhibiting our investigation by unnecessarily telling them the right to remain silent, which you do have. Make no mistake about it. You do have a right to remain silent effectively at all times. Um, Miranda, the case is all about when are the police required to remind you of that right, which is not every time. The second issue, it does have a legal component to it, and that's the part about the right to counsel. If this person is not actually in custody, and I'm giving that it truly is a free Miranda warning, one you haven't earned yet, then that part about you have a right to a lawyer present before and during questioning is simply not true. You don't have a freestanding, always available to you Fifth Amendment right to counsel. That right only attaches to you when you're being subjected to custodial interrogation. If there's no custody here, there's no Fifth Amendment right to counsel. My point is, we're being less than truthful with this person about what his constitutional rights actually are. And what's the next thing you tell him about the lawyer? You can't afford one, you want one, we'll pay for it. We're not doing that. You don't have a right to it. We're not going to pay for a free lawyer to which you're not entitled. So you're not accurately stating what their rights are if you're giving a free Miranda warning. So why do we do it? Because I think a lot of officers they recognize we do it. The reason is simple, I think, is that we don't have a good understanding of the rule. Many of us don't have a good understanding of this rule. It looks very simple. This is the Miranda formula. When do I have to give a Miranda warning? If the person I'm questioning is in custody and the questioning that I'm engaged in amounts to interrogation. So custody plus interrogation. I've got to have both factors present in order for Miranda to be required. And unfortunately, in my experience, in law enforcement training in general, we don't do a phenomenal job of explaining these two principles. The case law, some of it doesn't help because there's some ambiguities. So Mark asks a good question. Mark, we're going to get to that in just a second. What if I have someone detained and I'm investigating? Do I have to read a Miranda? The quick answer is probably not. Probably not. Okay, but maybe depends on the situation. But for Terry, probably not. And that's where most of our over Mirandizing occurs, is in our Terry stops, investigative stops, traffic stops, and things like that. Um, what about the ask if you have to have subject in handcuffs? Yeah, so that's where they're not in custody, but they're in handcuffs on a Terry stop. That's where Miranda might potentially come in, and we're gonna drive down or drill down into that in just a second. Both Mark and Tyler's questions are very timely. So what I want to do is first let's define these two terms. Okay, once we get the definition, now we can maybe apply it to some of our situations. Let's do interrogation first. What is interrogation? This one's a lot more. It's a lot more intuitive as far as the definition goes, and it's a lot easier. And we have fewer interrogation issues. But what case does it come from? It comes from a case called Rhode Island versus Ennis. And I'm not going to get into to the facts, but it involves two armed robberies of taxi cab drivers in the vicinity of this school where handicapped children attend the school. And the police we've arrested our suspect, which is this guy named Ennis, and we're looking for the gun we're looking for this shotgun that he used to in one of the robberies shoot and kill the taxi cab driver. So the suspect is being transported back to the police station by two patrol officers, and the officers are talking to each other about this unaccounted for gun. Ennis, he's under arrest, and he has already been given Miranda, and he says he wants a lawyer, so he's invoked his rights. So we're not supposed to interrogate him. But the officers instead, they're having a conversation with each other, talking about, I hope we can find the gun. I'd hate to see one of those handicapped children find the gun and hurt themselves. And they go back and forth for a few minutes. And what does this prompt Ennis to do? It prompts him to speak up. They're not talking to him, but he can hear what they're saying. And he says, fine, I'll show you where I hid the gun. And he leads them right to where he hid the gun, which was under a pile of rocks on the side of the road. Now, that's a very self-incriminating statement. Two statements. I'll show you where I hid the gun, and then he tells them it's under those rocks right there. And the prosecutor wants to use those statements. But his lawyer says, no, you can't use those statements. Your officers interrogated my client after invoked his right to counsel, which you are not allowed to do. So that's the issue in this case. Is this an interrogation? Of course, the prosecutor says it's not. It's just two officers having a conversation. Ennis just volunteered this information on his own. So it goes all the way to the Supreme Court, and the Supreme Court, the first thing they have to do is say, well, we've never actually defined interrogation in our cases. So let's do that first. So here it is. This is the definition of interrogation for purposes of Miranda. It's words or conduct, express questioning or word or conduct that a police officer should know is likely to elicit incriminating responses from the suspect. So what we get from this is it's not just like direct questioning, which is what most of interrogation is just directly asking questions. It could be conduct. Like for example, if I've got a homicide suspect in front of me and I lay out a bunch of gruesome crime scene photos, that's probably an interrogation. Okay, it's conduct that should know is likely to elicit incriminating responses, which is fine. The next question is he in custody? If he is, you got to give him Miranda. So let's apply this definition to what the officers did here, and the Supreme Court says this was close. This was a close one, but it was not an interrogation. It was not an interrogation. It was not conduct or a conversation the officers should have known was likely to elicit incriminating responses. Although it was close, but there was no evidence that they were trying to appeal to some known sensibility that he had or sensitivity to handicapped children. Although they were hoping he would do this, but it was close. I would never advise an officer to engage in this kind of conduct because you change one little fact in this case, you have yourselves an unlawful interrogation. But there it is. There's our definition of interrogation. Words or conduct that are likely to elicit incriminating responses. Um, so Stanley says traffic stop, smell marijuana, take them out of the car, question them without handcuffs. Um, Automatic reading Miranda. No, not necessarily. We don't necessarily have to read Miranda, and we're going to get into that right now with what does it mean to be in custody. And let's look at this chart right here. These are our officer citizen contacts. The voluntary contact. Miranda simply not required here because there's no custody. Arrest on the other end, easy. We all know this rule already. If you're under arrest, you're by definition, you're in custody. And if we want to interrogate there, of course you got a Miranda. But let's focus on the Terry stop / traffic stop. Okay, what does it say right here? Miranda is usually not required. That's a true statement. Okay, because what is the definition of custody that we're going to be focused on? It's not custody in the Terry stop context is not whether the person's free to leave or not. That's the test for whether you've seized someone or not. Rather, the test for whether somebody's that's the Fourth Amendment test. Are you free to leave? Yes or no? It's custody if we have this. This is the definition or the test, if you want to think of it like that, for custody. Is the person under arrest or is their freedom of movement being restrained to the degree normally associated with formal arrest? That's the question. And the part I have highlighted in red, that's for your Terry stop. So the question on a Terry stop, obviously he's not under arrest. So the question we want to ask is, are we restraining this person's freedom of movement to the degree normally associated with a form with a formal arrest? That's the test. It doesn't matter, what I'm asking him about. It doesn't matter what the type of questioning is focused on this Terry stop. What matters is, do we have an arrest-like environment? So I sometimes I'll paraphrase this or shorten this down. I'll say custody is under arrest or subjected to arrest-like measures. That's how we determine on our Terry stops if we have custody. Have we subjected this person to arrest-like measures? Yeah, he's not free to leave because it's a Terry stop, but that's not the test for custody. So these are examples of restraints on freedom of movement not normally associated with being arrested. If you've got this guy on your Terry stop locked in the back of your police car, okay, that is the type of restraint that average people who watch television would associate with somebody being arrested, not briefly detained for questioning. Somebody who is in handcuffs. When Elliot and Olivia slap the handcuffs on you in Law and Order, that means you're going to jail, right, on TV. So handcuffing someone on a Terry stop is an arrest-like measure. This Terry stop starts having arrest-like feel to it. And then the number of officers that are present, like involved in the questioning, like surrounding the person while being questioned, that's another factor. If I've got, it's not unusual to see one, maybe two officers having a conversation, but if I've got, as the picture here, like a platoon or half a platoon or officer, or if some of you, that's your entire police department, those are also that's also an arrest-like situation, being surrounded by a bunch of officers. Um, so now we all know as police officers, these could all be Terry stops. All of these pictures could be Terry stops, or they could be arrests. We don't, but we would need more context. But average everyday American citizens would associate these people with being arrested. So here's the point. If your Terry stop looks like these, now you're moving into that realm of custody. Just because I have somebody detained sitting on the curb, as Derek asked on a traffic stop, I say step out of the vehicle, sit on the curb. That doesn't mean they're in custody. That doesn't mean they're being subjected to arrest-like measures. It just means I'm having them step out of the car, sit on the curb. They're not in custody yet for Miranda. These are the kinds of things. Seth, yes, we're going to talk a little bit about people who are incarcerated, and we want to talk about other matters that involve that other matters not related to why they're in custody. Yeah, we're going to talk about those in just a moment. So, physical restraints is what we're focusing on. Now, I will say it's not automatic. Here's an example of this case here out of the Fourth Circuit. Just because you put somebody in handcuffs on a Terry stop doesn't automatically say they're in custody. But it is a strong factor. I say it's a strong factor. In fact, I would say that if you have somebody handcuffed on your Terry stop or locked in your car, unless you've taken some efforts to mitigate the effects of those handcuffs, like tell them they're not under arrest and explain why you have them in handcuffs, safety reason, flight risk, unless you've done something like that, then I strongly would suggest you read a Miranda warning in that situation. But most Terry stops don't involve those things. Most Terry stops are just two people having a conversation. One's a police officer, one's a private citizen. So in our field interrogations, our Terry stops, what we're looking for is he in custody, is how many officers do we have present? If it's more than two and they're like on top of this person, like surrounding them, then that's probably an arrest-like measure. We want to start thinking about Miranda. If they're handcuffed or they're locked in your police car, that's when we're in Miranda territory. But you can still do it without Miranda as long as you mitigate it. You're not under arrest. The reason you're in handcuffs is so and so, and there is case law to support that. Now, what about in the police station? If I'm interrogating somebody in a police station, this one is actually comparatively easy. The test here is the same as to determine if somebody's in being detained under the Fourth Amendment. The test is, would a reasonable person feel like they're free to leave? That's your Miranda custody test in a police station or in a jail. So I've got somebody in the interrogation room, and I want to know, do I need to read this guy Miranda? The question is, would a reasonable person feel like they could just get up and walk out of this room? So, how many officers are present? What was the language we used to summon the person? Is the room locked, unlocked? Are we armed? Age of the person. Where in the facility is it? Are we down in the public lobby? Are we up upstairs in the secure area of the facility? All of those questions would need to be examined, and then in totality, would a reasonable person feel like they're free to leave? So this notion of not free to leave, it does have its place for Miranda custody, and that's when you're in a police station. Now, of course, what if somebody's imprisoned, like they're serving a sentence, or whether it's at a state prison or a sheriff's office? The Howes versus Fields is a very important case. It says that just because you're serving a prison sentence or a jail sentence doesn't necessarily mean you're in Miranda custody. So this is your new home. Okay, this is where you live now. So it's kind of like being out in public for somebody on a Terry stop. So the question isn't, would a reasonable person feel like they're free to leave the jail? No, they're imprisoned. It's, would a reasonable inmate feel like, if I'm serving a prison sentence, would a reasonable inmate feel like I could just get up out of wherever this interrogation is occurring, the security office, some interview room? Would a reasonable inmate think they could just get up and go back to their cell? Yes or no is what we're looking for. And here's some factors that courts look to consider. Nick says, not to get too much in the weeds, we're probably already there. Person is voluntarily in the back of a police vehicle. Yeah, I would not say that's custody as long as they're or it's not an arrest-like measure, as long as they've consensually done it. Yes, I don't mind sitting in the back of the police car. A reasonable person would know that a police car typically locks from the outside. You can't open it from the inside. So if someone is voluntarily sitting in your police car and we have none of these other physical restraints on that person's freedom of movement, then yeah, they're not in custody for purposes of Miranda. Yeah, Dimitri, inmate, common area, classroom, open door, leads to housing unit. Yeah, tell them they're free to go back to their cell at any time. You don't have to talk to me. I'm assuming he's serving a sentence then, because this is his new home. You don't need to Mirandize him in that situation. To ask him criminally, to interrogate him about criminal matters, whether it occurred in the facility or outside the facility. The Baylor admonishment. It's basically if it's the same thing as if they're in custody. It's kind of just basically getting someone to acknowledge they realize they're free to leave. Which, if I'm doing this interrogation at a police station, a good idea is obviously tell them they're free to leave, let them know they can stop answering your questions at any time. I think that's what we're getting at with the Baylor admonishment. It's just an extra layer of protection where we explicitly tell our person, you're not in custody, you're free to leave at any time. It's just to ensure that they understand that they're not in custody. So here you can see the factors here for prison interrogations. These are the things that we're going to look at to determine if he's in custody in prison, not just the mere fact that he's there. Now, Miranda, there he is right here. Real quickly, he's arrested by the Phoenix Police Department for kidnapping and sexual assault. He's interrogated afterwards. He confesses. When his trial rolls around, it turns out his confession is going to be the critical piece of evidence. There's very little physical evidence. They did a lineup where the victim picked him out of a lineup, but that's the lineup they used. Now I added the red circle right there, but that's a very suggestive lineup. Number one is Miranda, and she described her attacker as wearing glasses, so he's the only one with glasses, so it must be him. That's not going to be an admissible lineup. So we need the confession. And his lawyer is trying to have it suppressed. He says the problem is his client was never told he had a right to have a lawyer present during that interrogation, which he was not told that, and he did have that right. So therefore, he says his confession was not voluntary. Well, the trial court disagrees. So yes, he wasn't told he had a right to a lawyer, but it was nonetheless voluntary. So he's convicted, appeals to the Supreme Court. The Supreme Court overturns the conviction and says, the mere fact that the police fail to tell someone they have the right to counsel prior to a custodial interrogation, and they have the right to remain silent, we're failing to give that warning, will render the statement, any subsequent statement, inadmissible. It doesn't mean it's involuntary. It just means it's inadmissible. And that's the big deal with the Miranda case, is that we have this new rule where we have to tell this person of the right to remain silent. So what does that mean for Miranda? It means a new trial. So let's see. I saw a couple questions. Miranda over the phone. No, if they're not in your custody. If you're over on the phone, I've had that question many times. As long as as long as they're incarcerated at the jail, they're also not, in an interrogation room, locked into an interrogation. I'm assuming they're sitting in the lobby where they normally talk on the phone to a family member. So not in custody there. Father comes to pick up his kid that he left home alone, asks questions in the police station while waiting for somebody to arrive. Other parties' information leads to his arrest. I'm assuming the dad. Questioning was before arrest. No, it is Miranda needed. I mean, on those bare facts, I don't, he's standing in the lobby of the police station. As long as we haven't insinuated that he's not free to leave, um, it sounds to me like this is a voluntary contact right here. So Miranda probably not needed without having all the details of the interrogation, but it sounds like a voluntary questioning to me. Robert says if you give a proper bailer or behaler, however you pronounce it, subject then proceeds to list incriminating responses. Yeah, if what he says amounts to enough to make an arrest and it's a pretty serious crime, like would a reasonable the question the answer to the question, Robert, is would a reasonable person who basically just confessed to whatever crime you're referring to would think I'm not going to be able to go home tonight. I'm not sleeping in my own bed. Then yes, at that point I would before any further questioning, read a Miranda warning. But if it's some really minor crime where you have complete discretion as whether we let this guy go now, maybe arrest him later, merely confessing does not necessarily put you into Miranda custody. Serious crime, I think it probably would. All right, so Ernest Miranda, or Ernesto, how he went by both names. So he gets his new trial, but there's new evidence. So we can't use his confession, but fortunately there's new evidence. His girlfriend is going to testify against him because he confessed to her that he committed the crime. So he is convicted a second time. He's sentenced to state prison. He's paroled in 1973, 74. And when he gets out, he realizes he's relatively famous. So he, as any good American would do, he attempts to capitalize on his newfound fame well, I'll talk about how he passed away, by signing and selling Miranda rights cards. And that, I believe, is actually his signature. And so, clever idea. But he dies 2 years later. How does he die? Stabbed to death in a bar fight. The guy that stabs him, arrested, brought in for interrogation, read his Miranda warning, and invokes his rights, refuses to answer questions, is released, and is never formally charged for the crime. Hopefully, the irony of that situation is not lost on anybody here, that it's because of the Miranda warning and the death of Miranda that led to him not answering questions and ultimately led to him not being charged. So that's how Miranda meets his demise. And also, when the coroner searched Miranda's clothing, he found a bunch of these signed Miranda rights cards in his pocket. All right. So, yes, Robert, karma is a bitch in this case. Now, do I have to read the Miranda warning in a specific way? No. The Supreme Court has said this numerous times. They said we've never said you have to say it using these exact words, this exact order. You just have to get the substantial gist of the warnings out there, and the court is good to go. If you're looking for a case where an officer just barely met the minimum requirement, this Florida versus Powell case is a good example. Been caught for a year or so. All the clarity I can get, apps understandable. Anytime we're asking guilt-inducing questions to suspect, we must read Miranda. Absolutely not. That's only half the formula. So remember, you have to have custody plus those guilt-inducing or guilt-seeking questions. If this is a consensual encounter, I can ask all the guilt-seeking questions I want if he's not in custody. So you got to have both of them. He's got to be either under arrest when you ask those questions, or he's got to be subjected to those arrest-like measures that we talked about with our Terry stop. So just asking guilt-seeking questions, which is what interrogation is, does not render somebody owed a Miranda warning. Now, the waiver. This is the important part for us because they can waive their rights. So what makes a waiver valid? Okay, so we need to know this because the burden of proof is going to be on us. Somebody asked me recently, well, why do you have a picture of Ronald Reagan and Nancy Reagan there? I said, because they're waving. We're talking about waivers. They're waving. I know it's spelled differently. It's a different type of waiver. That's why it's funny. Or at least That's why I think it's funny. You might not agree with me. Anyway, what makes it a valid waiver? Two things. The waiver's got to be voluntary. That's what this whole quote is all about. It's got to be voluntary, which means of the person's own free will. Thanks, Nick. Thanks. At least somebody appreciates my sense of humor. So voluntary, no threats, no promises, no coercion of their own free will. And the second requirement, it has to be given knowingly. They have to understand. We have to prove this person understood what their rights were, the consequences of waiving those rights, and we prove that by showing we gave a proper Miranda warning and we asked the suspect if they understood their rights. We got some kind of acknowledgement, and then as long as there's no evidence of threats or coercion, we have ourselves a valid waiver, assuming he did in fact waive those rights. Now, there's two ways to get a waiver. We can do it explicitly, which means after we give the warning, ask if he understands his rights. We ask him one more question. I call it the waiver question, which is, do you understand these rights? I'm sorry, having these rights in mind, do you wish to answer questions? And if he says yes to that, that's called an explicit waiver. Nothing wrong with it. It's good to go. But the Supreme Court says you can also rely on an implicit waiver, where what that is we read him the warning. Do you understand your rights? Yes. And then we just start asking our questions, start our interrogation. The act of him answering questions is him waiving the question, waiving his rights. So either way, one is not usually better than the other. Let's see. Stanley, yeah, I'm sorry, yeah, Robert, good example with the DUI and not needing Miranda before we do the SFSTs. If I have evidence, just need their statement before arresting them, do I need to read the waiver? As long as even if you intend to arrest, that's a good question. Even though you intend to arrest them, as long as you haven't communicated that in any way before you begin your questioning or during questioning, no, you don't have to read Miranda. Check out Stansbury versus California, a Supreme Court case that talks about that. The uncommunicated intent to arrest is not relevant for purposes of Miranda. It's not until you tell him I have a warrant for him or you're going to arrest him, that's when it becomes obviously relevant. All right, so waiver, explicit or implicit, we can go either way with that. Um, Personal preference. Now, I would advise an explicit waiver in a couple situations where the person has previously invoked their rights, like during the same custodial setting. We'll talk about in a moment when you can go back after they invoke their rights. If they previously invoked and now they're all of a sudden they're allegedly waiving their rights, I would opt this time to get them on the record saying, yes, I'm waiving my rights, but it's not required. And the others, if we're trying to get a waiver of the Sixth Amendment right to counsel, which we'll talk about at the very end of this section. No, so a waiver is not required before interrogation. I'm going to skip over Burgess. It's kind of a complicated case, but let's talk real quickly about the public safety exception. There is one where we can we can ask guilt-seeking questions, even though they're in custody without Miranda, and it comes from a case called New York versus Quarles, where officers arrest this guy Quarles in an A&P supermarket, and he has an empty gun holster. And so after they had been in a foot pursuit with him, they say, "Where's the gun?" And he says it's on aisle 7. And they go and they collect the gun, sure enough. But he's a convicted felon, so he's admitted that he was possessing the gun when he tells them where it is. But they never read him Miranda, and the Supreme Court says his statement is still admissible. It's self-incriminating. It was an interrogation, but it was not the purpose of the questioning was not to get him to incriminate himself. It was to address the public safety interest of we got to find this unaccounted for gun. We're in a public area, and therefore the public safety need outweighs apparently his right to privilege against self-incrimination. So very narrow exception. Don't see it a lot, but there is a public safety exception to Miranda. All right, let's talk about the specific rights. And I want to jump ahead just for time purposes. I am going to talk about the Sixth Amendment right to counsel. That's completely different than the right to counsel we refer to in the Miranda warning. This is your right to a defense attorney, the Sixth Amendment right to counsel. Your Miranda warning, that's about I call it your interrogation lawyer. That's your lawyer for an interrogation that you're involved in. This is your Sixth Amendment right to counsel. This is your right to an attorney once you've been formally charged with a crime. But it does have some implications for future investigation on our part. Derek says public safety exception seems to apply to. not doesn't really apply to DUI investigations. Once we have this person detained, they're not that immediate public threat anymore. It's the guy with the gun who we have a gun somewhere, somewhere in the grocery store unaccounted for. Well, we need to get this thing now, otherwise somebody is gonna find it potentially and hurt someone else. William says in a DUI arrest, is a person who's intoxicated able to understand have and waive the rights. That's one of the things to consider. I mean, somebody who is highly intoxicated, we might have a hard time showing that they knowingly waived their rights. But just somebody who's like an 08 or a 10, yeah, they're coherent enough that they could certainly waive their rights. But somebody who's like falling down, 2-0, 3-0, like almost like unconscious levels of intoxication, yeah, we might have a hard time proving they knowingly waived their rights. During a traffic stop for some administrative violation, sole occupant of the vehicle, exit the vehicle, no rest-like measures, search versus via search waiver. Locate powder substance. Is Miranda required regarding the substance? Probably in that case because I'm assuming it's an arrestable offense and sounds like he's already on probation or parole. So probably going to that's like an automatic violation right there. Like if it is a reasonable person would think that my answers are going to cause me to end up going to jail tonight, then they're in custody. Okay, then you're going to treat that person as in custody. But if it's just like a little bag of weed, he's not on probation, he might get a ticket out of this thing. He's not going to be in custody just because you ask him about it. Yes, it was just the statement about the gun, Dimitri, that was admissible. Yeah, he was still charged with being felon in possession, and we were able to use that statement even though it wasn't Mirandized because the purpose for asking it was not to collect evidence, it was to find the gun. Yeah, a kidnapping investigation. Like, where is the victim? That could be an example of a public safety question we could ask. And the key is the answer. We could still use it against him because we didn't have that purpose, the criminal investigative purpose. All right, once someone has invoked their rights, and again, and I apologize, I got a bunch of slides in here, but time is running short. I really want to cover this. Once a person has invoked their rights, what does it mean for future interrogation while the person stays in custody? Okay, so first of all, it doesn't matter whether it doesn't matter what the person's arrested for. There's a wide misperception that if I have someone under arrest for crime A and I read a Miranda, he says, I don't want to talk or I want a lawyer, that we can then just change the subject and say, well, you want to talk to me about this other crime that you're not arrested for. We don't have enough to arrest you, but we want to talk to you about it because you're a suspect. You can't do that. Once someone invokes their rights, questioning on all matters. Yes, Stanley, I believe we do have. I'm pretty sure we have a recorded version of I think the 2 or 3 hour Miranda presentation on the website. But I can also answer questions too on the Search and Seizure show afterwards. Um, so it's not charge specific. Once someone invokes their rights, their Miranda rights, we got to stop questioning on all matters immediately. And the case that says, and in case you're curious, is Mathis versus United States from 1968. But when after he invokes, when can I reapproach him? Obviously, he can change his mind anytime. The suspect can say, "I changed my mind. I would like to talk to the officer," and he can reinitiate. But so let's say he stays in custody, and we want to maybe take another crack at this. We want to take another bite at the apple, perhaps. Can we reinitiate? Well, the answer is it depends on which right he just invoked. Okay, did he invoke his right to silence? He just says, "I don't want to talk." This one is more forgiving for police. We do get another bite at the apple if it's just silence. And Michigan versus Mosley is our case that says once he invokes his right to silence, all questioning stops immediately, okay? But after a period of time where we leave him alone, we don't pester him, we don't bother him, we don't threaten him, we leave him alone for a sufficient period of time, we can go back to him while he's still in the same custody, give him a fresh Miranda warning, and just ask him if he's changed his mind and be willing to talk to us. It was about 2.5 hours in between interrogations in Mosley, and the Supreme Court says that was sufficient. So that was sufficient in that particular case. So it does, a couple of hours at least. Fresh Miranda warning. But the key is, in the meantime, we didn't do anything to threaten or coerce the person in the process. Working narcotic sales case. Of the suspect's phone, write a warrant for it, invokes his rights. Can I ask him for his password? Passwords are tricky. That's a long discussion. If you want to ask it again during the search and seizure show, that'd be great. The case law on this is not entirely clear. Some people say yes. Some courts say yes, you can ask for a password. It's not protected. Others say no, it is protected by the Fifth Amendment. So no Supreme Court case on that yet. Um, God up his atrocities. Do you understand was a violation of his rights? No. So the question is, I guess after we've arrested someone, Brett says we read him this declaration of the charges after he's invoked. I guess you're being charged with X, Y, and Z. Do you understand? Him saying he understands, that's not a violation of Miranda. He's just saying he understands that he's being charged with a crime. His response, I understand, is not self-incriminating. So it's not a Fifth Amendment issue in that case. Someone doesn't want to speak after giving Miranda, then changes their mind a few minutes later for a few more hours. Do you need to read Miranda again? If it's just been a few minutes, so I read Miranda, he says I don't want to talk, but then he on his own he says 5 minutes later I changed my mind. No, you don't need to read a new Miranda warning. But if it's been a few hours, some time has passed, some significant time, yes, I would read another Miranda warning. What if he invokes his right to counsel, though? This is where it's pretty unforgiving as far as police and initiate interrogation. He says, "I want a lawyer." Um, we have what's called the Edwards rule, and the Edwards rule, it's very simple. It says no more police initiated interrogation. Period. So there is no leave him alone for a little while, give him a new warning, and ask him if he's willing to change his mind, or if he has changed his mind. That would be a violation of what's called the Edwards rule. It's a violation of his Miranda rights. Edwards says that once someone invokes their right to counsel, any subsequent waiver of counsel is presumed involuntary unless he reinitiates it or his lawyer is present during that interrogation. So no more police initiated interrogation. I'm just restating the rule right here about anything, about any matter once he invokes his right to counsel. And it doesn't matter whether the second officer, maybe another officer goes back after he's invoked, doesn't realize this guy has told the first officer that he wants a lawyer. Arizona versus Roberson says we don't care. You got a duty to find out. Okay. You have an obligation to find out. So it doesn't matter if the second officer is unaware. You're not allowed to say, well, I didn't know he had previously invoked. The Supreme Court says, well, you got an obligation to find out because Edwards says any police initiated interrogation about anything is presumed, any waiver of that right is presumed to be involuntary. So no, leave them alone for a couple of hours. Some of you have probably heard of the 14-day rule from Schatzer. Um, the Schatzer says once there's been a 14-day break between custodial interrogations, then this Edwards rule it just goes away. So the clock gets reset. So if I arrest him on Friday, he says he wants a lawyer. He's released Saturday, but he gets rearrested on Sunday. So he gets rearrested one day after he gets released from custody. He still has Edwards protection. That second during that second day, that's Sunday. So we can't interrogate him unless he initiates. But if you've got 14 days between your custodies, now we're starting from scratch. That's what the 14-day rule is. There's a lot to Schatzer. I definitely recommend reading Schatzer. Particularly if you do a lot of interrogations of people who are serving prison sentences, Schatzer is important there as well. All right. I'll skip through that, and I want to talk last about the Sixth Amendment right to counsel. We still got to give a gun away, and I want to make sure I get this done within the hour. I see other questions popping up. If you guys wouldn't mind hanging out and asking them, they look to me to be pretty good questions. If we could hold them till after the webinar, just to make sure I can finish this, that'd be awesome. Um, Sixth Amendment right to counsel. Remember, your right to a defense attorney. So once someone has invoked their Sixth Amendment right to counsel, he's been arraigned. He's gone before the judge. He says, "I want a defense attorney to represent me on this crime." That means the police are barred not just from interrogating him on that matter. We can't even deliberate any illicit any incriminating information. Like, for example, we can't send an undercover officer to pose as an inmate to be a cellmate and try to get him to talk about this charged crime. That would also be a violation of the Sixth Amendment right to counsel. But the Sixth Amendment right to counsel, though, it is charge specific. It only applies to that matter, whatever he's been arraigned on, whatever he's been formally charged with. We are prohibited from deliberately eliciting incriminating information about that topic. We can talk about unrelated crimes that we might suspect him of. Just the typical Miranda rules would apply there. And the Sixth Amendment right to counsel, it also applies whether he's in custody or not. Maybe the judge gives him a bond and he goes home and he's at home just awaiting his trial. We can't go to his house and initiate contact with him there and attempt to talk to him about the charged matter without his lawyer present because that violates his Sixth Amendment right to counsel. Um, so it's not just interrogation. It doesn't apply just in custody, but it can be waived. The suspect can initiate this conversation if he wants to. He can say, "Hey, officer, hey, detective, I want to talk to you about this robbery I've been arraigned on." He can do that, but we need to give him a Miranda warning, get him to waive that right. I would go for the explicit waiver, but in that case, if he does, we can talk to him, and you don't have to have the lawyer's permission. This is his right, and he can invoke it and he can waive it whenever he wants to. But the key is here, we're not initiating that interrogation on that, or that interrogation on that formally charged matter. Now, Miranda, as you can see, we've been at it for almost an hour. We Nick was afraid to get down in the weeds. We're already in the weeds, but there's a lot more to Miranda. Um, to do justice to it, it probably would take about at least 4 hours. We could probably talk about Miranda all day. But what is nice about Miranda issues, if you can say there is one good thing about them, and I say this to all my classes, these are usually not time sensitive questions. Like I don't usually have to know the answer right now. Some of these things maybe, but this stuff we're talking about right now, this right to counsel, he's been formally charged. Can I go talk to this guy? Okay, we don't need to know the answer right this second. If we don't know the answer, we can call somebody and try and figure it out. One piece of advice: call a smart person. Call a smart person. Don't call the guy or the girl you went to the academy with who guessed their way through all the legal tests, and that's who you're asking for advice. Call a smart person. Tell them what you got. I bet you can probably, between the two of you, three of you, however it is, work it out and get the right answer. Because we don't want to screw this stuff up. This is some pretty valuable evidence in a lot of the cases that we could potentially risk losing. So, all right. That was a lot. I covered a lot. I probably had way more in here than I probably should have added to this topic for today. I probably should have kept it a little bit shorter, but there's a lot more I wanted to get to. But I apologize for that. But we can do another one. I can maybe do like part two of this, and we'll look at the schedule, and I might just actually do that because there's a lot more to talk about.